Oh
but
shit.
I'm assuming you're talking.
Oh
But
shit.
I'm assuming you're talking about Don Wells meeting up with him
Oh, yeah, you can
type
go back
thing.
there. We can just start there too. Yeah. But go back to how you met Don, how that
Um,
all started.
that would have been back in 2005, October, somewhere up in there, December of '05. Hurricane Katrina hit in October, and I moved up here for a few months. And I was working for Tucker Drywall as a subcontractor. Me and Don and many other ones worked side by side on all these units. And that's how I met Don. We all did drugs, so he's a big cokehead back then. But drunk, and he's still with Candace. He's driving an old blue Ford truck.
Okay.
It actually broke down at his house. It was still there. I seen it recently when summer was.
So back in 2005 when you met him, for sure that summer wasn't even a thought then.
No, ma'am. No, ma'am. No, he had his
So
oldest son, I believe. Uh,
yeah, we don't have to. Yeah, we don't have to mention their names.
Jody.
We try to
Jody.
leave them. Yeah, no, we don't have to mention their names. So you were kind of able to work with him. You worked with him for many years then before this happened.
No, no. Actually, in '05, I only stayed up here about maybe 8 months. I went back after Katrina rebuilt. Well, I was from Louisiana, so my area had the water over the house. So
Hey
there was a lot of
Dudley,
work.
Don
Yeah.
jumped up here. Hey Don,
Hey, how y'all doing?
we're
Hey, Donnie.
doing
What's up,
good.
husband?
We were just
I would,
chatting with Dudley about how y'all met.
yeah, I would like to talk about that right away, Mr. Dudley. When we
I
first
guarantee
met,
you do.
when we first
But we're
met,
gonna hey, hold on,
well,
Don. We hold
no,
on, no,
for him
I
to
know,
say,
but let's
okay,
I know.
well,
I want you to
no, it
I
makes
want
me mad for him to sit there and lie and say
Makes you
I worked
mad.
him.
no,
Yeah,
I
because
know.
I worked with you the first day I met you. Richard Tucker brought you to my job, and I worked with you till 11 o'clock, dude, and said, I'm going home. I can't work with you. I got to figure this out. The second day, I worked with you till 11 o'clock and said, I can't work with you no more. I never done no cocaine with you, dude. Don't be fucking
I,
lying.
I never said you did cocaine with me. I said we all did drugs and you had a cocaine problem.
Not me.
That
I
was
didn't
what
do
you
no
said, and you
drugs.
was a drunk.
I don't even know you. I don't even
Dude.
know you. Didn't even know you.
Oh man, come on, bro. Look at
I
your
didn't
rap
even
sheet.
hang with you. Don't know you. Never said anything like that to you. And I wasn't
Okay,
doing
so
cocaine. You might have been, but I wasn't.
Did you
dude, you said
you said Don was acting funny on June 16th, like the day after June
the
15th?
day I got the day
So
I
you
think that
guys
was
were
like the day
working
I got
again
fired.
that day together, right?
No.
So he was at work.
We was working
Don was
together,
at work.
dude, for like a month,
Can you
almost 2 months.
Don was working a lot though, right? He was always at work. Can you
Yes, ma'am.
Is there anybody that you've had dealings with that are shady that would do something revenge wise just to get back at you, to hurt you, that you owe money or that you had illicit dealings with in some way? We know that you've had some conflict with the law concerning drugs and different things. Is there anybody that you've gotten sideways with?
I fired a lot of guys for being on meth. And the last guy I fired a day before, pretty sure, I can't prove it, but he was way out there and I fired him. And the very next day, my daughter disappeared.
Hello, everybody. I hope you're doing well. Today, I want to help the cause for Dudley Ajan. I'm not sure if that's how I say his last name, honestly, but it's something like that. He has been accused a lot lately. By the way, who is Dudley, right? Dudley is the former co-worker of Donald Wells. He is the one who worked with him for about 2 weeks before Summer went missing.
how
Man,
long
you need to take
Donnie, how long or Donald, how long
that was
How long have you guys worked
Yeah.
together? Let's.
Like I said, in 2005, I worked
We didn't work together. We were
with him
subcontractors.
for
Might have
So-
worked 2 days together.
2 days.
Days,
We were subcontractors. I did my house. He did
whatever.
his.
I don't know what he did after. That's the way that went. Didn't know him, worked with him for 2.5 days. That's all I knew of him.
Okay, so fast forward a little
Yeah,
bit
but that was all we needed to know.
to when did you
That's
Like,
right.
before up until the
Worked
days before
for
Summer
3
went
months.
missing? When did you start
Yeah,
working for
that's-
Tucker again?
I was on.
He was
catch-up
working-
crew, and they put me with Don, who's the
Mikey
city
and
department.
Steve-O. Well, yeah, I figured
Mikey
I'd try
and
to help you.
Uh,
Mikey and Steve.
I was working with. Mike. Yeah, Mike.
Mike,
Try
yeah.
not to dox anyone, boys. Please, please, please. Let's not dox other
Yeah,
people.
no last name.
Let's.
No,
We just don't want to. You
no.
guys
trying to
have
figure out
all
who
been
he was
through
talking
hell. We
about.
don't want to put that on someone else too.
Don has
Mm.
terrible feedback.
So Dudley is very, very sick of being drugged through the. He's very sick of his name being drugged through the mud, and so he has been faced with there's just no decision but to fire back and tell his side of the story. So I wanted to do this with him in the most respectful way as possible, because he does not want any drama in his life. He doesn't want people contacting him. He doesn't want any more of this to affect his life more than it already has. His wife is also very tired of it because she's bullied online, people thinking that her husband has something to do with Summer's disappearance. And from my time speaking to them, just my opinion, and I could be wrong, but they seem like very decent people. And when I say decent, I mean they prefer a life that's normal, where they go to work, they pay their bills, they keep a clean house, they take care of their kids. That's the life that they choose for themselves. But it's ever since Donald Wells brought them into the mix of Summer's disappearance and trying to shift that blame and I guess pivot it onto Dudley, it's wrecked his life. For 3 months, he was out of work. For 3 months, he was down in the dumps, couldn't make ends meet. And to make matters worse, Donald Wells, in the end, ended up shorting him $1,500.
I
So-
wanted
I have
no
feedback.
part of this problem.
Yeah, a little bit,
Don
Don.
gave me.
I don't know what to do
Don
about
threw a
it.
lot of heat on me for whatever reason, but he didn't pay me my
I
money.
didn't.
So no, you didn't.
That's,
You ripped me
that's
off.
another
and then
lie.
you
That's
accused
another
me.
lie.
Dude, you
That's
are a
another
lie.
lie.
You're a fucking
Hold
joke.
on.
You know
Hold
what
on.
else?
I paid you every dime I owed you.
Dude, I wish I could get in front of you. 'Cause if I'd have known you
Yeah, I
for the
wish
way
so
you are,
too.
I
I
promise
wish so
you, I'll come
too.
over.
No, Don, don't
What's up?
say anything. Don't say that. Let's not get in trouble.
No.
Okay, so I really want, boys, come on. So I have a question. And chat, I'm sorry,
sorry,
I'm
Cher.
not paying attention. No. No,
It's the first time I'm talking to this dude since he's accused me of this shit, so I'm sorry.
Okay, now I have a question. If
I
he
haven't
paid
accused
you, Don, did you pay him
He had
everything you
accused
owed
me.
him?
I did.
Okay.
$300, dude. Come on. I was
But
supposed
did
to
you
have a
guys
$1,500 check that week.
All right, so since both of you are up here, let's go back to what
He's really, really tired of the attacks, but he's also really sick of the fact that his life can't just go back to normal. And it probably won't for quite a while. That's why I wanted to help them as a couple nip this right where we can without crowds and craziness and all that. I just want to put it out there as honestly as I understand it to be and tell their side of the story.
Guys, Sweetie Pie Lowe did an interview with Dudley, and I hope nobody gives her shit about it, because it kind of just happened. She was not trying to step on any toes. I have the link to this video in my description, and I'll put it in the chat. But I did ask her if it's okay if I play some of this, and we discussed part of it. I knew about it yesterday afternoon, and I was dying to hear it. It was gonna come out yesterday, but it got extended because of some things she had going on. But
Hey, Dudley.
Are you?
I'm good. How are you?
I'm good.
All right. I just want to make sure that it's loud enough for everybody. Thanks for letting me call you so late. I know it's late there.
Yeah.
I mean, we're in the same time zone. I'm in Florida, so.
Weekend on Monday. Early Monday morning, I don't know, I heard something about the boys saying, where y'all going? They were carrying Summer out the house, Don and Candace. She was head down on his shoulder, carried her out and left. So I don't know if that was Sunday or Monday. But I seen him Monday morning.
Gotcha.
I never saw her. He was in his Subaru, so obviously.
Gotcha.
And you said that was the first time him going to work in a Subaru.
And you said you heard that the boys said that.
I heard something. I heard somebody say something about that. The boys looked and they saw Daddy and Mama carrying Summer out of the house with her head down like she was sleeping.
Do you remember who said that? Do you remember who said that?
One of the boys.
So the boys.
Yeah.
Her brothers.
Yeah.
This was when everybody was under investigation.
And then you saw him on that Monday before he got fired crying or distraught on a
He
Twitter.
wasn't crying. He was definitely disturbed. Mentally disturbed.
And you don't think
he
it was
lost
like,
his pride.
and you don't think it was because
Summer
he
was
was,
his prize.
yeah, gotcha. And you don't
Okay.
think it was drug related or anything like that? Like he just hadn't had any,
No.
no, it was something
I've
more
seen those
personal.
days.
Okay.
I saw what that day was like.
Gotcha.
I've seen them.
Gotcha.
That wasn't that day.
Gotcha. Gotcha.
He lost his prize. Summer was his prize. Okay? That was his little trophy. He even said if anything was ever going to happen, it was going to be on Candace's watch.
So he knew. He
No,
knew
he
that
knew.
he knew that she was a piece of shit. Gotcha. I can't imagine. I'm so sorry, guys.
Jonathan Lee Riches investigates. I got some breaking news, everyone, on the Summer Wells case. A co-worker of Don Wells, Dudley Ajan, was just booked into the Sullivan County Jail on drug charges. Dudley Ajan, the man that worked with Don Wells, the man that claims that Don Wells fired him the day before Summer Wells went missing at the job site. Well, he was just booked into jail. That is his mugshot. It's dealing with manufacturing drugs, manufacturing meth, and drug charges. It's from a case that was filed in Sullivan County General Sessions Court, Criminal Court on 4/3/2023. So it was filed a few weeks ago. But just last night at 8 p.m., he is booked in the county jail. I just reached out to his wife, Linda, to ask him what's up with this, what's going on with this. And she told me that she's been separated from Dudley for the last 6 months. Didn't provide me any more details, just that she has been separated. What's going on here, people? Remember, I interviewed Dudley Ajan about what transpired around the time Summer Wells went missing. He sat down and actually talked to me. You need to go check that video out, that interview. It's very interesting. He shares a lot of details. Well, you know, Summer Wells is still missing. Don Wells, Summer Wells' father, has said that he believes whoever is responsible for Summer Wells' kidnapping has something to do with meth dealers or drugs. This is very interesting. Very interesting. Or do you think it's connected in Summer Wells with the Dudley Ajan being arrested, or do you think this is just something separate in his own issues? What's going on? Addiction is a serious problem. Dudley Ajan does have a prior history of drug charges. He was working Tucker Drywall before he was fired. He said he subsequently got other jobs and was working at job sites and whatnot. But man, drugs and addiction is a serious thing, and it seems like Dudley Ajan is struggling. Or is there something else to this? I'm covering the Summer Wells case. Summer Wells went missing June 15, 2021, has not been found. Where is Summer Wells? Dudley Ajan. Sad situation. Subscribe to my channel, hit the notification button, and check out my Summer Wells playlist. Got a lot of videos up covering this case extensively, up-to-date information, what transpires. We'll talk soon. Everyone be safe. God bless. Justice for Summer Wells.
I do have your Cash App link in my description.
Okay.
You know, if everyone else is sharing,
I just made that.
I was like, yeah, you did. Yeah, but I asked you to. So before the haters, you know, they can say whatever. But if we've got almost everybody else up here sharing their links, why not?
Okay.
So that is
You
in
always
the
do that, yes.
Yep, I do. So it doesn't differ for Dudley, and it shouldn't. If you're gonna drop Dawn and Candace's or Jody Sue's or anybody else's, even your own, let's drop theirs too when they are taking their time to be a guest on your show, is how I look at it. So it is in the description should you guys want to send him a little gift.
Jonathan Lee Riches investigates. Got some breaking news, everyone. Summer Wells case. Dudley Ajan is wanted by authorities. Dudley Ajan is wanted by the Sullivan County Sheriff's Department. Dudley Ajan, a co-worker of Don Wells. The Summer Wells case. Summer Wells been missing since June 15th, 2021. Dudley Ajan was fired by Don Wells the day before Summer Wells went missing. Well, he's wanted.
People that you're about to see are fugitives that we need your help to capture. These are dangerous individuals who are on the run. I'm Sheriff Jeff Cassidy, and this is Sullivan County Sheriff's Most Wanted.
Our first fugitive for this month's Most Wanted is a Dudley Raymond Ajan Jr. His date of birth is 6/11/1979. He is a white male, 5'11", 200 pounds. His charges are aggravated burglary and domestic violence assault.
Sounds like the sheriff in Sullivan County is not playing. Jonathan Lee Riches investigates. Got some breaking news, everyone, in the Summer Wells case. Dudley Ajan, the former co-worker of Don Wells, he just got arrested again. Dudley Ajan is now in police custody on new charges. Arrested again. Check this out. So according to arrest records, Dudley Ajan was taken in custody today, 6/27/2023, booked on numerous charges: assault, domestic ASSAULT, aggravated burglary. What is going on here? Many charges. This is bad for Dudley Ajan.
So I'm going to be discussing that with you today. Don Wells and Dudley Ajan, or Ajan, I don't know how to say the last name. They started working together about 2 weeks before Summer came up missing. The way Dudley described it to me is that Don started to noticeably sabotage him at the job site. And it would be things like how much mud to use. It would be like Don accusing him of stealing mud from him, to where he later finds in a shed that there's a bunch of old mud that's gone bad that Don was accusing him of taking, which didn't happen. It's
stuff in the yard.
He had a ton of buckets of mud, man, that was blue lids. And I swear he was blaming me for stealing Tucker's materials and putting them in my storage unit, which I was taking materials, holding it in the storage unit because it was taking it from job to job. So sometimes it would go in the storage unit. I always kept up with it, brought it back. But he had about 50 buckets of brand new, looked like molded blue, lightweight mud. And I tell you what, it wasn't very long when the cops went there, all the buckets were gone. So you know he didn't want Tucker to have seen all the buckets. They were not open. So there's material thief was there.
So
things like that really have left a bad taste in Dudley's mouth for Don. In addition to that, it's also the weird things that he would pick up about Don's drug use. Dudley insists that if he had to pass a drug test right now, he could. He says he smokes weed, and he has smoked weed with Don before, but he's not done the other drugs. And maybe in his past he did. We didn't talk about that, but that's not his life right now. He's got kids. He has things to worry about. And
Our first fugitive for this month's Most Wanted is a Dudley Raymond Ajan Jr. His date of birth is 6/11/1979. He is a white male, 5'11", 200 pounds. His charges are aggravated burglary and domestic violence assault.
And the law, TBI's been talking to him, and he's got an alibi where he was.
Is there anybody that he's been involved with that you think might be trying to get even with y'all by taking your daughter?
Not that I'm aware of.
Shot up was Alan Ajan's on Goshen Valley Road. And I even looked at old deeds and things. And then I looked up who Alan Ajan was, and that's Dudley Ajan's, where they were living on Goshen Valley Road. So Dudley Ajan and Alan Ajan were neighbors. They both were living there. So it's kind of funny how Dudley says that he doesn't know any of these people when his uncle was brought into a huge
right, his
battle,
house was shot
like
up
in
by,
court and everything over it. Was
his
shot
house was
up
shot up
by
by.
Jason Arnold. Jason Arnold.
Wow. So these people all
Yeah.
connect, guys. Yeah,
They all
it is kin to
connect.
Dudley. It is kin to Dudley and Alan. You said his name's Alan Ajan.
Yeah. Alan.
Yeah,
Yep.
he's
Alan
Dudley's.
Ajan is the brother of Dudley Ajan, who is senior, who was Dudley Ajan Jr.'s dad. And if you look up, and I pull some things up here, like clipped, so you guys can just go, and kind of watch these clips of things where it shows connections and the different things, and talking about him, Jason being missing.
Let me show you this. Ajan Allen Mark, 2024, 7/29, Laurel County, Kentucky booking. "59 years old, 5'7", gray hair, brown eyes, 200 pounds, race white, sex male, arrested by U.S. Marshals. Booked 7/29/2024. Charge: federal prisoner held in transit court, serve out. Bond details: no bond allowed. I have been able to find out what he is arrested for because I just found this. But yeah, Pretty interesting, huh?
United States District Court for the Eastern District of Tennessee at Greenville. Alan Mark Ajan, Petitioner v. United States of America, Respondent. Memorandum Opinion. On January 30th, 2006, Alan Mark Ajan, a federal prisoner, filed a petition to vacate, set aside, or correct his sentence by a person in federal custody. Attached to the petition was a letter in which Ajan sought additional time to file a memorandum in support of his petition. On March 3, 2006, Ajan filed a motion to amend his petition and a 32-page memorandum in support of his original petition, in which he requested an evidentiary hearing. The United States responded in opposition to the petition, and Ajan filed a motion to supplement his petition along with 2 supporting affidavits. On February 6, 2008, Ajan filed a 54-page reply to the government's response, and on April 23, 2009, Ajan filed a second motion to supplement his petition. The matter is now ready for resolution. The court has determined that the files and records in the case conclusively establish that Ajan is not entitled to relief under the law for all issues raised by him, except for one issue, on which the court will receive further briefing. The record also establishes that no evidentiary hearing is necessary, and Ajan's request for an evidentiary hearing will be denied. However, counsel will be appointed to represent Ajan on the remaining issue. This opinion and order will dispose of all issues raised by Ajan, except for the one issue, and for the reasons that follow, Ajan's petition lacks merit, and the motion will be denied in its entirety, except for the single issue. Procedural background. Ajan was indicted by a federal grand jury on July 23, 2002, along with co-defendants George H. Simpson and John Vance Bowers. Ajan was charged with conspiracy to distribute and possess with the intent to distribute 5 grams or more of methamphetamine, conspiracy to distribute and possess with the intent to distribute a quantity of methamphetamine, possession with the intent to distribute 5 grams or more of methamphetamine, possession with the intent to distribute a quantity of methamphetamine, distribution of a quantity of a mixture and substance containing a detectable amount of methamphetamine, brandishing a firearm during and in relation to a drug trafficking offense, conspiracy to commit kidnapping, aiding and abetting kidnapping, and aiding and abetting possession of a firearm in furtherance of kidnapping, a crime of violence. On December 19, 2002, a jury found Ajan guilty of several of these charges. On April 28, 2003, Ajan was sentenced to terms of imprisonment totaling 646 months. Ajan's convictions and sentence were affirmed on direct appeal by the Court of Appeal by the Court of Appeals. Ajan then filed a petition for writ of certiorari in the Supreme Court, which was denied. Ajan's petition for rehearing was also denied. Ajan's petition was then timely filed on January 30, 2006. Factual background. The trial evidence is summarized in part in the Court of Appeals decision. The United States presented the testimony of 22 witnesses to establish Ajan's guilt beyond a reasonable doubt. Eric Alford, an officer with the Kingsport, Tennessee Police Department, testified that he stopped Ajan for suspected drunk driving on November 26, 2000, and as a result, Ajan was arrested. A search of Ajan's vehicle incident to his arrest resulted in the seizure of a quantity of white powder in a cigarette pack, digital scales, and a box of baggies. Alford also found a cell phone in the vehicle and called the last number dialed, reaching co-defendant George Simpson. Without identifying himself, Alford told Simpson that Ajan had passed out and needed help. Simpson responded that Ajan was his boss and told Alford to bring Ajan to a specific location where Simpson would meet him. The white powder found in Ajan's car was analyzed and determined to be methamphetamine. EAEA Special Agent testified that, in his opinion, a person simultaneously possessing 22.2 grams of methamphetamine, plastic baggies, and digital scales would be engaged in the distribution of methamphetamine. Returning to the events of November 26, 2000, Officer Hickman responded to the specified location to meet Simpson. Hickman observed 2 men wearing camouflage coveralls and bulletproof vests and carrying binoculars and 2-way radios. Hickman engaged them in conversation and asked for identification. One man identified himself as George Simpson. Hickman asked the 2 men for permission to pat them down, to which they consented. Hickman retrieved a loaded revolver from Simpson. 2 weeks later, on December 8, 2000, Curtis McDavid, Ernest Lynn White, and Ricky Howe met at a bar across the street from a motel in Kingsport, Tennessee, where White had rented a room for the night. After the bar closed, the three men went to White's motel room to drink a few beers. At about 2:30 a.m., McDavid and Howe left to wait for a taxi, but when it did not come, they returned to the room. During their absence, Ajan and co-defendants Simpson and Bowers had entered White's motel room. Ajan, dressed in black and wearing black gloves, struck White on the head with a walkie-talkie, displayed a pistol, and demanded money from White in payment for a drug debt. At trial, White explained the facts underlying the methamphetamine debt he owed Ajan. White testified that Ajan had given him an amount of crystal methamphetamine as payment for work he had done. When McDavid and Howe re-entered the room, Ajan ordered them to stay and directed Simpson to display a handgun. Ajan instructed McDavid, Howe, and White to empty their pockets, and he took their cash. Unsatisfied with the amount of cash, Ajan forced White to call his mother and ask for more money. When White's mother initially thought it was a joke, Ajan grabbed the phone and threatened her. After the phone call, Ajan and his co-defendants forced the three victims out of the motel room and into a car to meet White's mother. Simpson followed in another vehicle. The victims were told they would be shot if they tried to escape. When they were unable to find White's mother, Ajan and the others stopped at a market. Ajan gave a gun to Bowers and told him to shoot the victims if they moved. They left the market and drove back to the motel, where they saw several police cars. Ajan became angry and drove towards Virginia. During the drive, Ajan and his co-defendants discussed the fact that they were now involved in a federal offense. They stopped at another market in Virginia, and White again tried to contact his mother but was unsuccessful. The victims eventually escaped and were found by the police. At trial, during cross-examination, defendants suggested that McDavid had willingly participated in the events of that night, but McDavid rejected that version of events. Additional testimony was presented to support the charges against Ajan and his co-defendants. Standard of review. This court must vacate and set aside Ajan's sentence if it finds that the judgment was rendered without jurisdiction, that the sentence imposed was not authorized by law, or that there has been such a denial or infringement of the constitutional rights of the prisoner as to render the judgment vulnerable to attack. When a defendant files a motion to vacate under these circumstances, he must set forth facts that entitle him to relief. General conclusions of law without supporting facts are insufficient to warrant a hearing. To warrant relief due to constitutional error, the error must be one of constitutional magnitude that had a substantial and injurious effect or influence on the proceedings. If the sentencing court lacked jurisdiction, then the conviction is void and must be set aside. And to warrant relief for a non-constitutional error, Ajan must show a fundamental defect in the proceedings that resulted in a complete miscarriage of justice or an error inconsistent with fair procedure. In order to obtain relief under this statute, a petitioner must clear a significantly higher hurdle than would exist on direct appeal. Analysis and discussion. Ineffective assistance of counsel search of defendant's car. Ajan was stopped by Kingsport police officer Eric Alford on November 26, 2000, for suspected drunk driving and was subsequently arrested. A search of his vehicle incident to the arrest resulted in the seizure of a quantity of white powder in a cigarette pack, digital scales, and a box of baggies. The white powder was determined to be methamphetamine. Alford also found a cell phone in the vehicle. Alford dialed the last number dialed on the cell phone, reaching co-defendant George Simpson. Without identifying himself, Alford told Simpson that Ajan had passed out and needed help. Simpson told Alford that Ajan was his boss and asked him to bring Ajan to a nearby location. Ajan claims his attorney failed to properly present his Fourth Amendment claims. Characterizing the search of his car as an inventory search, Ajan claims that his attorney failed to challenge the search as being in violation of interdepartmental policy, and was simply a pretext for gathering evidence. He also claims that Alford's seizure and use of the cell phone was illegal. Petitioner's claim lacks merit. His trial counsel filed a motion to suppress. The magistrate judge held an evidentiary hearing and filed a report and recommendation finding no Fourth Amendment violation, and petitioner's attorney timely objected to the report and recommendation. The district judge overruled the objection and held that there was no Fourth Amendment violation. Ajan did not raise this issue on direct appeal. Petitioner cannot show deficient performance by counsel as to
Yo, this thing keeps fucking stopping. I'm gonna stop it.
to this issue.
Why is it doing that? Oh my god. It's just now taking my remaining characters off.
Ajan's argument that the November 26th search was an inventory search which was not conducted according to any established police procedures is completely irrelevant, notwithstanding Alford's testimony that he did an inventory of that vehicle. The record establishes that Ajan was properly arrested for drunk driving and that a search of his person revealed 2 or 3 bags of pills. When the occupant of a vehicle is lawfully arrested, as Ajan was, the passenger compartment of the vehicle and any containers therein may be searched without a warrant or further showing of probable cause. Even if the vehicle search were not permitted incident to Ajan's arrest, the discovery of pills on his person provided probable cause to search the car for contraband. Whether or not the occupant of a vehicle is arrested, warrantless searches of vehicles are permitted if there is probable cause to believe the vehicle contains evidence of a crime and exigent circumstances exist. This vehicle exception is applicable even in non-exigent circumstances, as long as the vehicle is mobile and law enforcement officers have probable cause to believe that it contains incriminating evidence. Where police have probable cause to believe that a vehicle contains contraband, they may search the entire vehicle and any contents located within it. It is quite clear that Alford's post-arrest seizure of Ajan's cell phone from his vehicle was also lawful since the seizure resulted from a valid search. Ajan argues, however, that Alford's use of the cell phone was illegal. The Fifth Circuit considered that very question and rejected Ajan's argument. In a related case, the Fifth Circuit held that since the cell phone was properly seized, the police were permitted to search the cell phone pursuant to the arrest. There was no deficiency in counsel's performance related to the cell phone, and this issue likewise lacks merit. Ineffective assistance of counsel failure to object to recorded detention center telephone call. Petitioner next asserts that his trial counsel was ineffective for not objecting to the introduction of a recording of a telephone call placed on December 7, 2002, by co-defendant Simpson to Ernest Lynn White, the victim of the kidnapping. While Simpson was incarcerated at the Washington County Detention Center, all inmate calls from the detention center are monitored and recorded by the jail computer system. Inmates are advised before each call that the call will be recorded. Prior to trial, Ajan's counsel filed a motion in regard to the recording. On the recording, Simpson encouraged White to avoid a government trial subpoena and told him the kidnapping charge would be dismissed if the victims did not appear for trial. As a result of petitioner's motion, portions of the recording that referred to Ajan were ordered redacted and were not heard by the jury. Ajan now asserts, however, that the recording of inmate telephone calls at the detention center violates the law and that his attorney's failure to object to its introduction on this ground constituted ineffective assistance of counsel. Ajan's position lacks merit for several reasons. First, the law is expressly limited to electronic communications as to which a person has an expectation of privacy. It cannot reasonably be argued that an inmate has any expectation of privacy in a jailhouse phone call where the inmate is expressly warned that the call is subject to monitoring and recording. Secondly, there is no exclusionary rule generally applicable to statutory violations. The Sixth Circuit has specifically held that a violation of the law does not warrant suppression of evidence. Therefore, it was not deficient performance for Ajan's trial counsel not to object to the introduction of the recording at the detention center on this basis. Furthermore, even if petitioner could meet the first prong of the test and establish deficient performance on the part of counsel, he cannot establish and, in fact, does not argue that he can establish any prejudice from the introduction of the recording. The trial court granted Ajan's motion and all references to Ajan were deleted from the recording and were not heard by the jury. Ineffective assistance of counsel fabricated facts evidence. petitioner argues that counsel was ineffective in failing to argue that a hearing was required because of what he refers to as fabricated facts, evidence, and contradictions in the testimony of several of the officers who testified in the case. Petitioner retreats somewhat from his initial position in his reply to the government's response to his petition, acknowledging that the initial claim was drafted by another inmate. Ajan expresses uncertainty if his argument, i.e., for a hearing was the only course of action my trial counsel was obligated to take. The rambling nature of petitioner's pleadings makes it very difficult to ascertain the precise issue being raised here, except that it is clear that petitioner accuses the law enforcement officers involved in the case of making false statements in their affidavits offered in support of their requests for search warrants and of giving perjured testimony at trial. In order to be entitled to a hearing pursuant to a specific case, a defendant must make a dual showing, which incorporates both a subjective and an objective threshold component. First, the defendant must make a substantial preliminary showing that a false statement knowingly and intentionally, or with reckless disregard for the truth, was included by the affiant in the warrant affidavit. Second, the offending information must be essential to the probable cause determination. If the offending information is excluded and probable cause still remains, a hearing is not required. A district court must uphold a search warrant if sufficient untainted evidence establishes probable cause. Ajan specifically points to the affidavit of Officer Glenn Craddock, which was submitted on December 9, 2000, in support of a search warrant for the residence of co-defendant Simpson. Ajan spends many pages of his memorandum discussing perceived false statements of Officer Craddock in the affidavit. Ajan further complains that Craddock's affidavit contains facts provided by third parties in violation of the law. Petitioner's arguments about alleged falsehoods in the Craddock affidavit are completely immaterial. The Craddock affidavit was offered in support of a request for a search warrant to search the residence of co-defendant Simpson. Petitioner Ajan has absolutely no standing to contest the legality of the search of Simpson's residence. To have standing to challenge the legality of a search under the Fourth Amendment, a defendant must have a reasonable expectation of privacy in the place to be searched. Ajan had no reasonable expectation of privacy in Simpson's residence and thus lacks any standing to challenge the legality of the search. As a result, Ajan would not have been entitled to a hearing even if he could have shown false statements in the Craddock affidavit, and counsel.
All right, I'm not really doxing anybody because it's already been said. We talked about some of these people in the live I did where Fred stopped up on Simpson Mountain. Bowers is a name that relates to Kathy Gordon. I missed what the thing was in here, but I was hoping maybe Kathy would come on and be able to explain a little bit more about what happened here. It's just odd to me that all these people were around in Summer's case and all these crazy things happened. What's going on with Cam? Yeah, Lady R. Definitely interesting. And I did put, now I had a problem finding what I had saved. I had the actual newspaper clipping the Burn Barrel had on, but I can't find where I put it, so that's why I put Burn Barrel on. When this is over, we'll go back and listen to the Burn Barrel, and then I'm just going to jump into Dudley Breaks His Silence on January 5th on J is for Justice, and then I have Chronicles of Olivia listening to this because we still have
both committed perjury at trial. He argues that.
So, okay, let me put this back on and get through it. I'm going to try not to chat and try not to interrupt so that you guys can finish listening to this because we still have like 15 minutes left. All right.
Counsel was not deficient in failing to seek such a hearing. One other issue needs to be briefly addressed. Ajan argues in his reply brief that the affidavit of Craddock was incorporated into Pugh's search warrant for Ajan's home, giving him the required standing to contest the legality of the search. A review of Officer Depew's affidavit in support of a search warrant for Ajan's residence establishes that the affidavit makes no reference to the Craddock affidavit. Petitioner's argument is wholly without merit. Petitioner makes the further argument that the affidavit of complaint filed by Officer Hickman upon Ajan's arrest for DUI contained numerous misrepresentations. That Officer Alford's affidavit of complaint filed in connection with the arrest of George Simpson on November 27, 2000, contained misrepresentations, and that Officer Hickman and Officer Melanie Church both committed perjury at trial. He argues that this fabricated facts evidence became an integral part of the federal prosecution. In particular, but not limited to pretrial motions filed by all defense counsel, government's responses to motions, open court colloquy at PTC motion hearing, magistrate's report and recommendation, and judge's orders. Other than to make conclusory statements about counsel's failure to contest these fabricated facts, petitioner makes no effort to explain what exactly counsel could, or should, have done differently or how he was prejudiced by counsel's alleged failure. Such conclusory allegations are insufficient. Furthermore, to the extent petitioner is arguing that the evidence against him at trial was insufficient to sustain a conviction, that argument may not be raised in this proceeding. As the government correctly points out in its response, petitioner was convicted by a jury after consideration of the trial evidence. Petitioner confronted all witnesses against him, and his claim lacks either factual or legal basis. Ineffective assistance of counsel chain of custody. Petitioner argues that his trial counsel was ineffective when he failed to object to the chain of custody in relation to methamphetamine that was in Ajan's possession. Ajan points to testimony of forensic scientist Jacob White and forensic chemistry reports which were introduced at trial. Petitioner makes no claim that the officers tampered with or altered the evidence. Physical evidence is admissible when the possibilities of alteration or misidentification are eliminated, not absolutely but as a reasonable probability. Where no evidence exists to indicate that tampering with an exhibit occurred, the court presumes public officers have properly discharged their duties. Challenges to the chain of custody go to the weight of the evidence, not its admissibility. This claim lacks merit as well. The record establishes, and petitioner acknowledges, that his counsel cross-examined the government witnesses on the issue, and he makes no claim that the evidence was tampered with, raising at most a claim of the mere possibility of tampering. Counsel's performance was in no way deficient, and absent evidence of tampering, no basis existed for counsel to object to the admissibility of the methamphetamine. Even were it shown that counsel should have objected, petitioner suffered no prejudice since the evidence was clearly admissible, and any deficiency in the chain of custody went to the weight of evidence only. Ineffective assistance of counsel multiplicitous counts. Petitioner next alleges that trial counsel was ineffective for failing to raise the multiplicity of counts 1, 2, 3, and 4 of the indictment in the case. Counts 1 and 2 of the indictment charge Ajan and others with a conspiracy to distribute and possess with the intent to distribute methamphetamine and lesser included offenses. Counts 3 and 4 each charge possession with intent to distribute methamphetamine lesser included offenses. The jury was instructed by the court to consider counts 2 and 4 only if they found the defendant not guilty of the charges in counts 1 and 3. The jury convicted Ajan on counts 1 and 3. An indictment is multiplicitous if it charges a single offense in more than one count. A multiple count indictment, however, based on the same underlying conduct, is not multiplicitous as long as each count requires proof of an element not required by the other. Counts 2 and 4 of the indictment in this case simply charge lesser included offenses of counts 1 and 3. Since Ajan was convicted of counts 1 and 3, counts 2 and 4 were irrelevant. Since counts 1 and 2 required proof of a different element, i.e., quantity, in counts 3 and 4 likewise required proof of a different element again, quantity, and since counts 2 and 4 were charged as alternatives to counts 1 and 3, these counts were not multiplicitous. Furthermore, even if counts 2 and 4 had not been set out as separate counts in the indictment, a lesser included offense instruction would have been given to the jury for counts 1 and 3. Even if counts 2 and 4 were multiplicitous as to counts 1 and 3, Ajan suffered absolutely no prejudice since he was convicted only of counts 1 and 3. Not only that, even if the jury had returned verdicts of guilty on all 4 counts, an option they were not given, the remedy would have been to merge the convictions for sentencing purposes. This issue lacks merit. Ineffective assistance of counsel petitioner's failure to testify. petitioner alleges that he received constitutionally deficient counsel when counsel failed to allow petitioner to testify on his behalf. The defendant correctly argues that the decision by a defendant to testify or not is personal and the right to testify cannot be waived by defendant's counsel on his behalf. In support of his claim, petitioner has submitted the affidavits of his parents, as well as his own affidavit. Ajan's mother states that during the lunch break on either the first or second day of the 3-day trial, she was told by her son's trial counsel, "Alan wants to testify, but I will not put him on the stand because it would not do him a bit of good and may hurt him." Ajan's father states that during the lunch break in the hallway, he was told by his son's attorney, "Alan wants to testify, but I do not want to let him do that for himself. He would only hurt himself." Ajan's own affidavit states that he was barred from testifying by his attorney and, if allowed to do so, would have truthfully testified that he was being railroaded. Both of Ajan's parents saw Ajan and trial counsel in a heated discussion after the government's last witness testified. After the presentation of some evidence, however, the defendant's attorney rested the defendant's case without calling the defendant to the witness stand to testify. The defendant's argument has been foreclosed by a recent decision of the Sixth Circuit. In a related case, the Sixth Circuit stated, although the ultimate decision whether to testify rests with the defendant, when a tactical decision is made not to have the defendant testify, the defendant's assent is presumed. Barring any statements or actions from the defendant indicating disagreement with counsel or the desire to testify, the trial court is neither required to address a silent defendant and inquire whether the defendant knowingly and intentionally waived the right to testify, nor to ensure that the defendant has waived the right on the record. A defendant who wants to testify can reject defense counsel's advice to the contrary by insisting on testifying, communicating with the trial court, or discharging counsel. At base, a defendant must alert the trial court that he desires to testify or if there is a disagreement with defense counsel regarding whether he should take the stand. When a defendant does not alert the trial court of a disagreement, waiver of the right to testify may be inferred from the defendant's conduct. Waiver is presumed from the defendant's failure to testify or notify the trial court of the desire to do so. This issue is controlled by the Sixth Circuit's holdings in related cases. Because Ajan did nothing to alert the trial court to his desire to testify, and because the trial court was under no duty to inquire, the district court correctly presumed that defendant Ajan waived his right to testify. Ajan did nothing before the conclusion of the trial to indicate in any way his disagreement with counsel or his desire to testify. Under these circumstances, this issue lacks merit. Ineffective assistance of counsel. Blakely Booker claims, petitioner claims that his appellate counsel was deficient when he abandoned petitioner's claim S under Blakely v. Washington and Booker v. United States. More specifically, petitioner contends that his appellate counsel failed to preserve a meritorious Blakely-Booker issue by not raising the issue in his petition for writ of certiorari to the United States Supreme Court. Ajan relies on a case called Ballard v. United States. Ajan was sentenced by the district court on April 28, 2003. His appeal to the Sixth Circuit was decided on December 15, 2004. On appeal, Ajan had argued that his sentence was unconstitutional under the Supreme Court's decision in Blakely. The Sixth Circuit disagreed, however, because of its decision in a related case, which held that the sentencing guidelines were not invalidated by Blakely. Petitioner then, by counsel, filed a petition for writ of certiorari in the United States Supreme Court, which did not explicitly raise his Blakely issue that the mandatory sentencing guidelines were unconstitutional. The petition did, however, challenge the district court's fact-finding for the purposes of sentencing Ajan as a career offender, citing Blakely. On January 12, 2005, the Supreme Court decided Booker, and on January 24, 2005, Ajan's petition was denied by the Supreme Court. On February 12, 2005, the petitioner filed a pro se petition for rehearing of the order denying his petition for writ of certiorari and specifically seeking a remand of his case in light of Booker. The Supreme Court denied the pro se petition for rehearing on March 21, 2005. Meanwhile, Ajan's co-defendants, Simpson and Bowers, had each petitioned the Supreme Court for a writ of certiorari and argued that the sentencing guidelines were unconstitutional. Simpson's petition was granted on February 28, 2005, and his case remanded to the Sixth Circuit for further consideration in light of Booker. On June 13, 2005, Bowers' petition was likewise granted. After Bowers and Simpson's cases were remanded to the district court for resentencing, Bowers was sentenced to 156 months of imprisonment, and Simpson was sentenced to 432 months of imprisonment. This represented a reduction from the original pre-Booker sentences for Bowers and Simpson of 55 months and 49 months respectively. In Ballard, a panel of the Sixth Circuit considered whether a defendant received ineffective assistance of appellate counsel due to the failure of her attorney to raise issues related to Apprendi v. New Jersey and United States v. Dale on direct appeal. While neither Apprendi nor Dale had been decided at the time of Ballard's trial, both were decided while Ballard's case was on direct appeal. The Sixth Circuit, while noting that it is not required that attorneys foresee changes in the law, nevertheless found that, once an important and relevant change does come about, we do expect counsel to be aware of it. The Sixth Circuit held, applying a plain error standard of review, that appellate counsel prejudices a client where the attorney fails to raise a meritorious claim on direct appeal where the error would have altered the outcome of the appeal. The government directs the court's attention to the Sixth Circuit's unreported decision in a related case. In that case, Burgess was convicted in the district court and sentenced under the mandatory guidelines scheme pursuant to a plea agreement, which included a waiver of his right to take a direct appeal. In an attempt to evade the appellate waiver, Burgess argued on direct appeal that he did not enter the plea agreement knowingly, voluntarily, and intelligently, and that the district court failed to comply with the requirements of Federal Rule of Criminal Procedure 11. While the direct appeal was pending, the United States Supreme Court decided Booker. In a supplemental pro se brief, Burgess argued that his trial counsel was constitutionally ineffective by not anticipating the Booker decision based on the court's previous decisions in Apprendi and Blakely. Although normally declining to review an ineffective assistance of counsel claim on direct appeal, the Sixth Circuit found the normal concerns about premature ineffective assistance claims to be absent in Burgess's case. The Sixth Circuit said, Burgess's trial counsel cannot be deemed ineffective for failing to anticipate the Supreme Court's holding in Blakely that the Sixth Amendment precluded the imposition of a sentence under Washington State's sentencing system based on facts not found by a jury or admitted by the defendant. See Blakely applying Apprendi. The Supreme Court had not even agreed to hear the appeal in Blakely until over a month after Burgess' sentencing. Nor can counsel be deemed ineffective for lacking the additional prescience to anticipate that the eventual holding in Blakely would be extended to the federal sentencing guidelines.
All right, guys, this is over.
Similarly, petitioner's appellate counsel in this case was not deficient in failing to raise an issue in his petition for writ of certiorari that the United States Supreme Court had not decided at the time the petition was filed.
There's 15 more minutes. However, I think you guys.
A lot of people coming up to our house.
Sat down with.
Hold on. I'm going to skip a little ahead.
Point counsel lies within the sound discretion of the court, and, in exercising that discretion, the court should consider the legal and factual complexity of the case, the petitioner's ability to investigate and present claims, and any other relevant factors. While the issues presented by petitioner are somewhat complex, they are not so complex that the appointment of counsel is required. The court notes that petitioner filed an extensive memorandum in support of his motion to vacate. The memorandum is well organized and supported by extensive citation to legal authority, indicating that petitioner is capable of presenting his claims adequately. The court also notes that petitioner has fully exhausted his claims, and the record is sufficient to resolve the issues presented without the appointment of counsel. Thus, after considering the factors mentioned, the court finds that the interests of justice do not require the appointment of counsel in this matter. Remaining issue. Despite the dismissal of the vast majority of Ajan's claims, the court recognizes that one issue merits further consideration. The petitioner has raised a claim related to the sentencing enhancements applied by the trial court. Specifically, the petitioner argues that the enhancements were applied based on judicial fact-finding in violation of his constitutional rights as articulated in Blakely and Booker. While the court finds that the petitioner's Blakely-Booker claim
It is a wonderful quiet area.
all other claims raised by the petitioner are dismissed.
Is there anybody that might be trying to get even with you, that would try to hurt you by taking your daughter?
I can't think of anybody.
Nobody in the drug culture, nobody owed money, nobody.
In our area, there's people that, you know, you got these boys and then you got these boys that you know, they're very prideful about, you know, kind of like, I guess, LA, you got the Bloods and the Crips. Well, these are hillbillies. I don't know.
Included. So I've heard all this cornbread mafia. It's the most absurd shit I've ever heard. My wife has lived down here all of her life. I have lived down here 10 years, and I've never heard of the cornbread mafia. 99.9% of everyone down here, they are good, solid, working, wonderful neighbors and Americans. Now, in any area, you've got certain people that do certain things, and you know it. And yes, there's a few bad seeds down in this area, but it is a wonderful, quiet area. It is near the Bays Mountain Planetarium. It's not far from there. So I wanted to clear that up. There is no cornbread mafia. I've never heard of that in my life. There might be 5 or 6 jackasses, and they can barely put 2 sentences together, much less form any kind of a mafia. So that is a myth. That does not exist. That is a lie. And as far as the meth labs and this or that, I've never heard tell of any down here. Now, like I said, there are 4, 5, 6 people that you know up and down this 6, 7 mile stretch of road that's considered Beach Creek. They're dumbasses. They're trouble. But it's like anywhere else. So there is no cornbread mafia. But I wanted to by doing this podcast, I wanted to give you the basics. I wanted to tell you some of the things that I knew firsthand.
But we don't associate with them. We don't socialize with them. We try to socialize with our church. We try to keep our kids in that church. That's our main goal. We try to stay completely far away from that kind of activity as possible.
Well, but you.
I messed up. I started going into part 2. Forgive me. That's not what I was supposed to do. We'll start with this part tonight. I'm still editing. Hopefully I'll have it done. And it may go into a part 3. But I hope you can see what I'm pointing out. Did we actually find cornbread? Is it possible? Think about the amount of people that are connected, and we didn't add the James Light stuff in yet. Next part. All right, guys. Peace and love. Hopefully I'll see you tonight. If not, I'll see you tomorrow early afternoon with the next part, depending how fast I can get it done. Talk to you soon. Peace and love, guys. Bye.